Nandipha Magudumana has filed an urgent papers with the Bloemfontein High Court. She filed them on Friday in a bid. Magudumana wants to have her arrest in Tanzania and subsequent deportation to South Africa declared unlawful. She was arrested in Tanzania heading towards the borders of Kenya with her partner Thabo Bester and a Mozambican accomplice on the 7th of April. Magudumana faces several charges including fraud, aiding Thabo Bester's escape from the Mangaung correctional facility last year and defeating the ends of justice, amongst others. We focus on what the law says about foreign arrests and extradition matters with attorney and director at Eisenberg and Associates, Gary Eisenberg. Gary, thank you very much for your time this morning. Does a person need to be a wanted person in their country of origin for them to be deported from another country?
No, what you've just invoked is a reason for a deportation not taking place. And I'll explain what I mean. Dr. Nandipha was found at the instance actually of the South African authorities in Tanzania. They alerted their Tanzanian counterparts to the whereabouts of Dr. Nandipha and her compatriots, including Thabo Bester. And she was facing, I think there was an arrest warrant for her for fraud and aiding and abetting, whatever the criminal charges were she needed to face in South Africa. And in my view, without having the benefit of reading her founding papers, it appears to me that the deportation was unlawful and that how she got to South Africa is really now the subject of a great deal of debate. And she has said that coming to South Africa in the way she did was unlawful. It was a contravention of international law. It was a contravention of South African law. And she was subject to a disguised extradition. That's how she got here. And she's unlawfully before the court.
What would be unlawful about the process without the benefit of having read those papers? But what would be unlawful? The fact that she did not face charges as yet in South Africa?
Let me explain what I mean by unlawfulness in this context. Where you have two different concepts, legal concepts, extradition and deportation. Extradition, and this is basic law, this is what our constitutional court has articulated a number of times, and also courts in the international arena, that extradition is made up of three elements. The exercise of sovereignty by the two states involved. In other words, the willingness of both states in consortium to have a person found in the requesting state surrendered to the requested state, in this case South Africa, by Tanzania. So there's a mutuality of will, you could call it, sovereign will. The second element is the actual surrender by the one state, in this case Tanzania, to South Africa, and the receiving state to have the person enter South Africa through a process which is legislated and subject, in this case, to the South African Development Community, the SADC Protocol in Extradition, which binds Tanzania and a number of other African countries to South Africa in this multilateral extradition agreement. And deportation is a unilateral act. The person is found in Tanzania as an illegal person and is deported by that country. And the destination of deportation, I must say, is irrelevant. So there are vast differences between the two legal processes.
Does it matter that she was with a convicted rapist and murderer who escaped from prison? It is yet to be tested whether she was with him willingly or unwillingly, but does it matter?
It makes absolutely no difference at all. Disguised extradition, extradition through the back door, as some courts call it, if the facts of those concepts are in place, then it makes no difference who she's accompanied by. It could have been by the worst person in the whole world. It makes no difference to the fact of how she actually got before the court, the criminal court in South Africa. And now the jurisdiction of the court that she faces is in doubt because of what I've just explained. A disguised extradition is condemned by judicial officers throughout the world, including South Africa.
When you speak of the jurisdiction of the current court, you mean specifically for this extradition matter or for the other charges that she faces?
I'm talking about her criminal matter. There was, I understand, an arrest warrant issued by a South African court for various criminal charges, and she's coming to face the music before that court in South Africa, and she's probably arguing again. I haven't read her founding papers. I don't know what she's already put before the court testing jurisdiction in Bloemfontein, but I'm sure anybody in her position would say that she's before the criminal court unlawfully, and the court has no jurisdiction to actually try her.
Meaning that a different court has jurisdiction to try her? Forgive my ignorance.
No, that she's actually before a court on the warrant in South Africa. She's been brought back unlawfully, and that the unlawful, let's call it surrender, or the way she was brought to South Africa, is sort of paints her criminal trial, and therefore it's fruit of the poisonous tree, if I can use that analogy, and therefore whatever ensues from her unlawful appearance in court is unlawful. It's tainted, it's rotten, it's polluted, and therefore should not take place.
Sure. Gary, thank you very much for helping us understand. Gary Eisenberg is the director at Eisenberg and Associates.